Hey, this is Ryan Witt, defense attorney here in Washington State. This is a quick video in our series for people who are unsure about hiring private defense. And this video is specific on just conditions of release. Now, conditions of release happen at a person's arraignment, and what they are is they're basically the rules laid down by the judge that are intended to ensure the safety of the community and of any alleged victims. Now, I personally think the conditions of release are a tremendously important phase in the case. And if you don't handle this right, I do think you're missing out on a really big opportunity for the long-term trajectory of the case. Now, they're important in all of the cases that come before the criminal court, but specifically, I think very important in DUI cases, physical control, and DV or assault cases. Now, when a person calls, let's say they call on a Saturday morning because they were arrested on Friday night. We will spend typically, hours over the weekend just going through and making a strategy with that person for how they're going to present and how can we can present them in front of the court come Monday morning when they have to go to the arraignment and the court's setting conditions of release. So, the things we can do are we're putting the person really in the light most favorable to them. That makes them look the least amount of risk to the community. And that just does take some time, and it takes some thought, and it takes a lot of work for both counsel and for the defendant or the accused over the weekend to look like they present no risk when it comes time for the arraignment. Now, if it's at all possible just to have no conditions of release, we'll waive arraignment. And then no conditions are set at all. And that can be favorable too. And as I said, I do think if you can really put your best foot forward at the arraignment for conditions of release and have them be as very lenient, it does often affect how the end result is going to be in the case. It makes a big deal in the DUI cases, and imagine it in like a domestic violence case. If we can convince the judge to not impose a no contact order so people can live their lives normally throughout the pendency of the case is almost always going to resolve in a very lenient fashion. Now, this is not a slam on public defenders, but they're not appointed to your case until the time of the arraignment because they're not appointed till a hearing of significance. And while there is somebody there at your arraignment just to help you enter the not guilty plea, they don't get to do any pre-hearing strategy with you or spend hours over the weekend with you. And you oftentimes don't get to talk to the one you're actually assigned until weeks after the arraignment. So you're really missing out on some critical time where you can be making decisions that are going to impact your case tremendously later. And I think also if you handle the conditions of release well at the arraignment, it can be a tremendous cost savings. Like, for example, if we argue, can we prevent the ignition interlock from having to be installed in your car? Or can we make the argument where there's no scram or alcohol sensing monitor going on your ankle? That's a big cost savings. And the grand one is maybe the state, because you have a prior, they're going to ask that bail be increased and you go back to jail. And that almost never happens when you go to court with private attorney and you are prepared for the hearing and you can make all your arguments. So I think just long term, it helps the case resolve in a more beneficial fashion. And it can be a real cost savings for you if you are prepared for those conditions of release. So hopefully this was helpful in you making your decision, and watch the other videos in the series. Thank you.